If you've been involved in a rear-end accident, you may think the issue of whether it's the other party's fault is cut and dry. Unfortunately, you're wrong. Under Missouri law, the defense allowed to instruct the jury that you stopped too quick. And because you stopped too quick, they rear-ended you. All too often, in almost every rear-end accident case I handle, the defendant always alleges that my client stopped too fast and they caused their client to rear-end them. So how are you going to handle that? I believe the best way to handle these is to get an admission from the defendant in the beginning that they rear-ended you and you didn't stop quickly. I also believe that it's imperative that you get physical evidence to support your position that you didn't stop quickly and that they rear-ended you, including photos of your car, photos of the defendant's car, photo of the roadway in which the crash occurred. Obviously, if there's no skid marks behind your car, damage to the back of your car, and damage to the front of the other car, support your position that you didn't stop short and they rear-ended you. Also, other factors go into play here. All too often, defendants make the argument, we rear-ended so-and-so, but it's not really our fault. It was just a mistake. The roads were wet that day. The roads were icy that day. I had proper following distance. I was paying attention. But because of the road conditions, I couldn't stop and I rear-ended them. All too often, those arguments are very effective because people don't believe they should be responsible for a mistake. And that's why at my firm, we don't see that as a mistake. We see it as a choice. They made a choice even though they knew it took longer to stop on a wet or icy road. They made a choice not to increase the distance between their car and the car in front of them. And in making that choice, it's not just a mistake. It's that choice that they made that led to your injury. So if you've been involved in a rear-end collision, I suggest you not consider the matter open and shut. I suggest that you contact somebody and discuss the matter with them to confirm that liability is as you think it is.